We are live now, Monica ma'am.
Go ahead. You can
Neha
start.
madam, should we start?
Yes, you can start already.
Okay.
We should start now. Yes.
A very good evening to all of you, and I welcome you all for this benchmark series, a dedicated episode on medico-legal aspects, and it is meticulously designed by none other than Dr. Sneha madam, and we all know her for her meticulous planning. She is the program coordinator, and the convener of this episode is Dr. Jyoti Banglowala madam, chairperson of Ethics and Medical Legal Committee of FOXI. And on behalf of both of them, I welcome all of you for today's webinar. And for this webinar, we have stalwarts from the medical legal field from all over India. And I welcome all the faculties, the chairpersons, and the delegates. And thank you all for joining this session. And I hope it will be a very useful session for all those who want to practice and who want to be medico legally safe, because we all know that in this era of medical legal litigations, we need to be really safe in our practice. And for that, we should know the law of our profession, to understand it, to know it clearly, and to implement it in the day-to-day practice. And before going for the further sessions, I would ask for a formal inauguration of this session, and then we can hand over to Sneha madam. Thank you. To begin with, I would like to introduce Dr. Sneha Bhuyar madam, who is really a wonderful person to be associated with. And she belongs to the society which is nearby to our society, that is Amravati Society. And we have been knowing her since long. She has many accolades and awards to her credit, like the International MS Signature Award for Phenomenal Leadership in 2020, the Dr. S.N. Malhotra Individual National Award for Outstanding Work in the Rural Obstetrics, Dr. Durusha Distinguished Community Service National Individual Award in 2022, Individual Award Champion of FOXI Award for 2 consecutive years, 20 and 21, and the Dhira Award for 22, Dr. Anandibai Joshi State Award by Government of Maharashtra, Lokmat Healthcare Excellence Award in 2020. She has delivered almost 300 talks, 10 keynotes and orations, and moderated more than 100
Thank
panels.
you, Sulega. Thank you so much. That would suffice.
Thank you, madam. And over to you, madam. Thank you.
Thank you so much, Sulega. A very good evening, respected seniors and dear friends. It's my pride and privilege to have all of you on board. My special respect and regards to chief guest for the guest for today's program, respected Dr. Rohit Bhatt sir, Dr. P.K. Shah sir, and Dr. Alpesh Gandhi sir. These three are not only past presidents of FOXI, but my inspiration, mentors, and guides. So they have been guiding me throughout my journey to FOXI, and I welcome them here on this program. I also welcome the convener for today's program, Dr. Jyoti Banglowala, who is the chairperson of FOXI Ethics and Medical Legal Committee. I take this pride and privilege to welcome our today's speaker, Dr. Nikhil Datar, but he will be joining shortly. I also welcome Dr. Sudesh Doshi, who will be the first speaker speaking on MTP Act. Dr. Dilip Warke, our dear friend, past chairperson of FOXI Ethics and Medical Legal Committee, who will be discussing some interesting medical legal case scenarios. Dr. Neeraj Nagpal, who will be speaking on the CPA, the much discussed and of course much faced act, you can say, Dr. MC Patel, who will be speaking on criminal liability, and of course our chairpersons, dear Dr. Ragini Agrawal, the past Vice President of Foxy, Dr. Shama Seth, the Vice President-elect of Foxy, and Dr. Rekha Rajendra Kumar, the President of Bangalore Obsgynae Society, Dr. Sudesh Doshi, past President of Pandharpur Society, and of course Dr. Jamuna Devi from Hyderabad, who is the Secretary of Telangana State Society, and Dr. Gorakh Mandrukar, a dear friend and Chairperson of AMOG's SOPs and Guidelines Committee, Dr. Meena Samant, who is at present the President of Patna Society, and of course Dr. Suman Sinha, both of them are very dear friends. Suman is the chairperson of the Vaginal Surgeries Committee for Foxy. And of course, I welcome all of you and my dear friends, Monica Ummathand and Monica Singh and Dr. Suiga Panat as coordinators of this program. This program we have started with the name The Benchmark because we wish to have the focus program on that particular subject with the speakers and chairpersons, authorities of the field who can, throw light on the subject as far as the clinical practice and the evidence is concerned. And of course, the chairpersons beautifully summing up. And I'm sure the delegates will be benefited from this. So with this warm welcome, I would like to have the blessings of my mentors. Saiti, may I have the CV of Dr. Rohit Bhatt, sir, please? So, respected Dr. Rohit Bhatt, sir, a very good evening and warm welcome to you. Sir, all of you know him as past president of Foxy, but sir is emeritus professor of Baroda Medical College, Department of Obsgynae. Of course, past president of not only Foxy, but also Isopower Nachi, past president of EOFOG, past vice president of EOFOG, I'm sorry, and the chairperson of Safe Motherhood Committee. Sir has got lifetime achievement from Foxy, Nachi, and also he was a former editor-in-chief of International Journal of Obsgynae, a BC Roy awardee as eminent teacher. So with this, we would really like to listen to your precious words of guidance, sir. Over to you, Dr.
Thank you.
Rohit, sir.
Am I audible? Am I audible?
Yes, sir.
Can you?
Yes.
Yes. Thank you very much, Sneha, for your good introduction for me. Dear friends, I feel very happy that I am almost coming to the end of my clinical practice without any legal problems. Our times were very simple. We didn't face any problem, but now times are changing. People are becoming more aggressive, and because of Google, the patients also become more active, and litigations are increasing. Therefore, I feel that this chosen the subject is extremely timely, which is very, very important for all of us to know. I feel that only in final MBBS there is no subject called jurisprudence. But in MD, gynecology and obstetrics, or for that matter, in any MD, any branch, there is no special subject taught, legal complications related to your specialty. I feel there's a time. It is very necessary that those who graduate in obstetrics and gynecology are exposed to legal problems that might arise in their clinical practice, because you know very well that if we get one litigation against us, changes entirely our attitude to life, and we are not able to do well in our practice. So it increases the tension if there's some litigation against us. So I thought how to remain safe is very necessary, and that for that I'm very happy that we got experts in legal. Today's talk will be by Nikhil, Dilip Walke, Dr. MC Patel, Meera Samant, and Ragini Agarwal. I feel that this is very important, that today's discussions will be very fruitful and guidance to all the members of our profession, how to avoid litigation, how to do a clean practice so that we don't have any problem. So I think with all this, my blessings and good luck, good wishes, I thank you very much for inviting me. Thank you.
Thank you so much, sir. Thank you so much. I take this opportunity to seek blessings of my mentor, respected Dr. P.K. Shah, sir. Saiti, can you just display the CV, please?
No
You
need.
know, all of you, yes, sir doesn't need any introduction, but I would just make some special remarks that in addition to President Foxy, President IAG, and of course the Dean of Ultrasound, College of Ultrasound, and so many posts he has held, sir is a very respectable personality, of course, a very kind-hearted personality, easily approachable, and a guide to many like me. So with this, I would request you, sir, to have the words of blessings and guidance for us. Over to
Thank
you.
you, Sneha, for your kind words. First of all, I thank Jyoti for being the convener for this very important webinar, the medical legal aspects. When I was going through the scientific program, I saw Dr. Nikhil Datta's name, who is going to cover MTP Act, but today it seems Dr. Sudesh Doshi will be covering that particular topic. Dr. Neeraj Nagpal going to cover CPA. Dilip Walke will be talking about different interesting cases, and Dr. MC Patel will be talking.
Sir, you are muted. Please unmute.
Sir, please unmute yourself.
Okay, now looking at the topics that we have today, these topics are not mentioned in any of our standard books. If you see, yes, Dr. Rohit Bhatt said. So it is very important that we listen to these people, because I have seen many of the gynecologists do not read these acts. There are so many acts that we have to know and remember and follow. So whenever I hear these medical legal experts, I get slightly scared at what is going to happen in the practice. But I think that is necessary. Somebody has to teach us exactly what we should do in our practice. So be aware of all these acts. You should read it and remember it. So I feel that Sneha has done a fantastic job by having this benchmark today with the medical legal aspects, and I wish her all the very best for Vice President's post of Foxy. And I wish her all the very best for all her future endeavors and future activities as far as webinars are concerned. I see so many important chairpersons whom I know well personally. So I think it's going to be a fun today, and we'll be all benefited by attending to today's seminar. Thank you very much for having me as a part of this webinar. Thank you and all the best.
Thank you, sir. Thank you so much. As I have been, talking to you all the time, that with my almost now 33 years of experience, whatever we have, experienced during the obstetrics and gynec practice, definitely, I have put up some of the points which I feel that whatever we have faced, the next generation should have that in advance and maybe as a guide, of course, from the stalwarts of the fields. And that is what the very essence of this webinar, sir. So thank you so much once again for all your appreciation and for your blessings. Thank you, sir. May I have the CV of, yes, Dr. Alpesh Gandhi, sir. Sir, I know you since so many years. Yes. Hello.
Can you give introduction only in one line?
Yes, sir, definitely. Saiti, please stop sharing this. So I know that is what I was going to do, sir. I know you since so many years, but in addition to your post and your whatever commitments you have done as Foxy president, I would just say as a human being, you have not only created followers, but you have created so many leaders who are coming forward as, the not only the office bearers or the chairpersons of Foxy, but they are doing great in their own fields. And that is what the true leader is. And you are the one of them, sir. So with this brief introduction, I would like to have Dr. Alpesh Gandhi and his words of wisdom for you. Over to you, sir.
Thank you, Dr. Sneha. Thank you for the kind words. I also enjoyed working with all of you when I was the president of Foxy. A very good evening to all of you. Today I am fortunate, I am very lucky. I feel myself very lucky to share this podium with two legends of Foxy, Dr. Rohit Bhatt sir and Dr. PK Saha. Just in last AICOG, I attended Dr. Rohit Bhatt sir's speech in managing committee meeting for 10 minutes about Foxy's history and Foxy's presidents. And I have seen him walking from lunch area to halls, academic halls. Sir, we are really very much inspired with your with all your activities in for Foxy. And I don't think would we be able to do so much work for Foxy after 20, 30 years
Thank you, always. Thank you.
or not. Dr. PK sir, when I was a committee chairperson since long, I am learning from Dr. PK sir, learn so much from him. But only I don't know why he has become Colonel PK from his mistake, that I don't know. He has changed a lot. Sir, I'm so happy to see you in so many webinars, very, very active. And you are so much participating in all the academic activities. I'm happy to meet so many friends in this webinar, Dr. Ragini Agrawal, Dr. Suman Sinha, Dr. Meena Saman, Dr. Sudesh Doshi, Dr. Rekha Rajendra Kumar, Dr. Jamuna Devi, Dr. Dilip Balke, and three very sincere coordinators. I was just late by 2 minutes, but I have received phone calls from all of them. So, Dr. Sneha, you are lucky that you have Dr. Suyoga Panath with you, Dr. Monica with you. All are very dedicated and sincere. I am also impressed with the series of these webinars, and the name benchmark itself suggests so many things. So I congratulate you for this name and continuing this good work, good academic work, webinars. Today, you have rightly selected a very good topic, as both the previous legends informed that we are not teaching this in our medical curriculum. So it is very, very important for all of us, but at the same time, we should also learn that the maximum at present, this is the time where maximum cases we are facing, and Gynec is one of the fraternity who is facing maximum medical legal cases. And ignorance or lack of knowledge is not an excuse. We have to learn this properly, all the acts, and how we can save ourselves from all these litigations. I would also like to mention here one thing, that during my presidency, we have prepared one uniform consents, which are very useful. And these consents are prepared with the experts of medical legal. It was jointly prepared with the Maharashtra National Law University, Dean, many faculties, past retired judges of High Court and Consumer Court were involved. And the person, Dr. Kantikar, who gave verdict against consent, was one of the expert for these consents. And these consents are also now translated by different states. It is translated in Kannada, it is in Marathi. Now it is also going to be translated in Hindi and Gujarati. So I I request all of you to use this consent in your practice. I think this is very, very useful consents. And these are the consents prepared by Foxy. You can consider its authority and it is there on our website. So please follow these consents. Today we have very important topics going to be discussed with so many legends of Dr. Sudesh, Dr. Nagpal, Dr. Dilip Balke, Dr. MC Patel. All are experts and experienced in medical legal field. So our delegates are going to be benefited a lot. Once again, my best wishes to this webinar, to this series, and my best wishes to Dr. Sneha for all his future endeavors. Thank you for giving me this opportunity.
Thank you so much, sir. Thank you, Alpesh, sir, for your blessings and best wishes. I thank all of you for gracing this occasion, and blessings to the program as well as blessings for me in particular, which I value the most. And I declare that this program is inaugurated, and I hand over this forum to Dr. Suyoga Panat and Monica Umbadan for further proceedings. So over to you, Suyoga, for the academic sessions. Dr. Suyoga.
Thank you, madam. Now we begin with the first talk. I think MC Patel sir has some emergency, so he needs to talk first. If he's there, I would like to invite MC Patel sir. I don't know whether I can see him. Yes, he has joined. So welcome, Dr. MC Patel sir, and he will be speaking on criminal liability. And for this talk, we have Dr. Ragini Agrawal madam and Dr. Shamal Seth sir as the chairpersons. I would like to introduce Dr. Ragini. She was the founder president of Indian Society of Aesthetic and Regenerative Gynecology, founder and president of Indian Academy of Dermatology and Gynecology, founder president-elect North India Gynec Forum NIGF 22, founder chapter governor AMWI Gurgaon.
Suyoga, Dr. MC Patel ko sun le.
Yeah, one
Yes,
or two points important.
Yeah.
Welcome,
Yes.
dear Ragini.
Yes, welcome, madam. Our next chairperson is Dr. Shamal Seth, sir. He is consultant practicing gynecologist at Kolkata and a medical legal advisor. He was the managing committee member and office bearer of the Bengal Obstetrics and Gynec Society for 13 years and honorary secretary, the Bengal Obstetrics and Gynec Society, and past chairperson of MTP committee of Foxy in 2015 and 17. And organizing secretary of Indo-Gyne 2017. I welcome you, sir, for this webinar. I would request Dr. Ragini Agrawal, madam, to introduce respected Dr. MC Patel, sir.
Thank you so much for your kind introduction. And I'm so happy to see Dr. Alpesh Gandhi. We have worked together for a year, and no doubt Dr. P.K. Shah sir and Dr. Rohit Bhatt sir is there. Aap sabko mera pranam. Sneha, you are doing a wonderful job. The word benchmark is too good, and the speakers, they are the really stalwart of the medical legal field. Whether Dr. Nikhil Datar, who is the person behind the MTP Act, or the Dr. Dilip Balke, my very close friend, and now Dr. MC Patel sir. Should I introduce him? I think whatever is written here is, I'm not going to read, you can all read. We all know that Dr. MC Patel sir is one medical legal consultant of the Foxy, who is always there for everyone, day and night, without any reservation. He helps to many doctors, and he is the person, if I give the number to anyone in the Haryana, he is always, I got back this report back. Thank you so much, Dr. Ragini. You have connected me with some person who has of a great help. So with this word, I welcome Dr. MC Patel sir. We are all eager to listen him, and my all best wishes to you, Sneha, to come flying this year. You really deserve it. So over to MC Patel sir. Sorry, मैं पढ़ती नहीं हूँ sir इसमें जो लिखा है.
No, no, it's
Thank
okay.
you. Thank you, dear Ragini. Thank you so much. Welcome, MC Patel, sir.
Please allow me to share my screen.
Yes, I think you can do that, sir.
Yes.
Saiti,
You are allowed to
please.
share, sir?
Yes, yes.
Yes. Is it full screen seen?
Not yet. Yes,
Yes,
Yes, it is.
seen?
Yes, sir.
Seen.
yes.
So, straightway to the subject. Thank you, Dr. Ragini madam, for kind words. Greetings from Statue of Unity, tallest statue of world, and we all are proud of that statue. Warm welcome all the delegates and wishing you a litigation-free practice. At the outset, I would like to thank organizers and Dr. Sneha Buyar and Dr. Jyoti Gunglowala in particular and Dr. Monica to reschedule my talk because I have to catch one train at 9 p.m. Just now I'm at Vira, and from one good friend, Dr. Deepak Desai home, I am delivering this talk. So thank you for the same. And before I go to the subject, this is my humble appeal.
So there is no volume.
And no volume,
Hmm.
only 1 minute.
Voice is not.
Yeah, voice is not there. I mean,
Only 1 minute, only 1 minute. Then I'll have to stop sharing and we'll have to do again.
Sir, I think
And
please
only
check,
1 minute.
please check your
Share
device
sound.
volume, sir. Yeah.
No. It's okay.
It's okay.
Now it will be heard.
शुभं करोतु कल्याणं
Audible now?
आरोग्यं
Yes,
सुखसम्पदम्
sir. Yes.
Respected seniors and dear colleagues, serving Foxy for years together on this auspicious day with folded hands and down head, I seek your guidance, blessings, and support to endorse my candidature for the post of Foxy President year 2026, election year 2024. Consistently working for Foxy and trying to visit even a smaller societies and to assist our common Foxian friends in any given situation, I have tried to serve Foxy. I assure to serve Foxy in the same way with the same zeal and enthusiasm. पथ का अंतिम लक्ष्य नहीं, सिंहासन चढ़ते जाना, लिए सभी को साथ, आगे है बढ़ते जाना. So please endorse my candidature for post of President Foxy, election year 2024. So today's subject, criminal liability. Discussing and if it is yes, then why? Criminal liability in medical practice. It is a major threat over and above civil litigation and litigation under CPA. Because as far as civil litigation or litigation under CPA is concerned, you have time because you are served with a notice, you can reply to the notice, and you have to face in district fora or in civil suit. And if at all you lose, then you have to pay a compensation. And if you are insured with insurance company, then insurance company will pay. But as far as criminal litigation is concerned, it is always individual. And here, if at all case goes against, then you have to suffer imprisonment or so. So before that, let us see when any patient comes to your clinic and once you accept her to treat, it becomes a contract or implied contract between patient and yourself about personal services. You are offering your expert services, patient pays for that, or patient promises to pay for that. So it is a contract. As far as negligence is concerned, we were taught during our forensic medicine study
two words, act of omission and act of commission. Act of omission means not to do something which a reasonable prudent doctor would do. Say, for example, if it is a case of full dose penicillin injection, a patient has come with penicillin injection, and naturally any prudent doctor would go for negative test dose and then only he will go with full dose. So if injection is given without negative test dose, it becomes a act of omission and it is negligence. As far as act of commission is concerned, means doing something which a reasonable prudent doctor would not do. Say, for example, if it is a planned surgery and surgery is planned under general anesthesia, but patient has come with full stomach. So in planned surgery, general anesthesia, full stomach, no prudent doctor would go. So if one goes, then it becomes a case of commission. So as far as this legal definition of negligence, if we go, then legal duty stands for acceptance a duty in a legal way. So as soon as you accept any patient to treat, your legal duty starts on that point of time. And if there is a breach of that legal duty or care owed to the patient by doctor, whereby patient suffers damage, it could be physical, psychological, or financial, and it constitutes negligence. But to prove negligence against any doctor, one has to prove four ingredients of negligence. That is, first, existence of legal duty, just I mentioned. As soon as you accept patient to treat, your legal duty starts. Breach of that duty due to carelessness or deficiency in service, it becomes a breach of that duty. And damage suffered by patient. Due to that breach of duty, damage suffered by patient, and doctor's conduct should be direct and proximate cause of such damage. So if these four ingredients are proved, then only negligence can be proved against doctor. But as far as today's talk is concerned, as far as criminal liability is concerned, these are some sections of Indian Penal Code which we have to be aware, because they may apply in our practice in criminal cases litigation. So section 304A, section 336, section 337, 338, 312 to 316 and 318, 269 and 272. These are some clause we will see one by one. But very important question comes, can doctor be prosecuted for negligence under section 304 or 304A Indian Penal Code? For that, we have to understand three words: intention, knowledge, and care. So as far as this intention part is concerned, any person inflicts any injury to anybody with intention to cause death, it becomes a case of homicide or murder, and it is triable under section 302. Usually in our medical practice litigations, intentional act is not there. So this action section usually do not apply. One more area as far as this part is concerned, and that is, any persons inflicts any injury to anybody with knowledge that this injury is sufficient to cause death in ordinary course of nature, then section 304 is applied. That is culpable homicide not amounting to murder, and there is a provision of imprisonment of 10 years. And usually this is also applied very in less cases. But as far as section 304A is concerned, causing death by doing any rash and negligence and not amounting to culpable homicide, that is a provision of punishment of 2 years. And usually in medical litigation, this section is applied. This is bailable at police station level only, so nothing much to be worried. But if section 304 is applied, it is non-bailable, and bail can only be availed at court level only. As far as section 304A is concerned, negligent act is not so severely punishable as intentional act, and most often applied in cases when patient dies as a consequences of or during medical treatment. And point in issue is whether doctor has taken adequate care and caution to prevent serious consequences by his action. And this section specially tries to punish carelessness and negligence which has resulted into death. Again, this question will be asked, can doctor be prosecuted for criminal liability? So, after some recent decision of Supreme Court, few have misconception that doctor cannot be arrested ever. But it is not like this. Under CRPC, police has tremendous power. Police can arrest anybody at any time without giving reason. But whenever they are taken to the court, police will have to justify the arrest. So police has tremendous power. They are building power. Where criminal liability is concerned, this is very famous judgment of Jacob Matthews versus State of Punjab, which was decided by Supreme Court in 2005. And it is landmark judgment as far as criminal liability in medical practice is concerned. So, at the time of deciding this Jacob Matthews case, one case was referred, that is Dr. Suresh Gupta versus Delhi High Court. And in that very case, young man with no history of any heart ailment, subjected for nasal deformity operation by Dr. Suresh Gupta, and on table patient died. On investigation, cause of death was found to be not introducing cuff endotracheal tube of proper size and at proper time to prevent aspiration of blood in respiratory passage. So, lower court and in due course High Court held doctor liable criminally under Section 304A, and appeal was preferred in Supreme Court, and Supreme Court was the criminal proceeding. Why? So, Supreme Court has very specifically mentioned for the act of negligence, he may be liable for tort, that is civil suit, but his carelessness or want of due attention and skill cannot be described to be so reckless or grossly negligent to make him criminally liable. So, observation on part of court during this case was, in present case, even argument of prosecution that aspiration occurred because of cuff endotracheal tube was not of proper size and at proper time and place, even then he can be liable in civil suit but not in criminal, because it doesn't make him criminally liable as act is not so reckless or gross. So in this case, inference held by the court was, to charge criminal liability, magnitude of negligence should be very gross and reckless standard of care. Otherwise, one will be prosecuted in liability. And in this case, one more case, Jacob Matthews versus State of Punjab. In this very case, fact of case was like this. Patient was of terminal stage of cancer, and only palliative treatment or nursing care treatment was offered by a hospital, and it was request on family members of patient, and patient was admitted. But one day he suffered breathlessness and patient expired, and case was filed against Dr. Jacob Matthews and a hospital, and section 304 was applied, and it was decided by lower court and in due course by High Court, and doctor was held liable criminally. Again, in this case also, appeal was preferred in Supreme Court, and doctor was at the time of deciding this case in Supreme Court. Supreme Court has come up with very important guidelines and inference. Doctor was qualified and he did his duty well. Oxygen cylinder not available or empty. Hospital may be liable in civil law, but doctor cannot be held criminally liable, and section 304A was passed. Point in issue at the time of deciding this case was, is there a difference in civil and criminal law at the time of deciding medical negligence cases? While dealing with cases of negligence in professional, is there need for judgment with a difference? Because there are two negligence usually we face, civil negligence and criminal negligence. And as far as jurisprudence concept of negligence differ in civil and criminal law, and what may be negligence in civil law may not be negligent in criminal law. So as far as civil negligence is concerned, simple lack of care is enough, sufficient to prove negligent against doctor, and case is filed by an individual. But as far as criminal liability is concerned, punishment depends upon degree of negligence, and it should be gross and high standard of recklessness. And as far as civil part is concerned, compensation demands depends upon amount of damage suffered by a patient. And principle of vicarious liability do not apply in criminal cases, and maxim of res ipsa loquitur is also not applied in criminal cases. So at the time of deciding case criminally, there are very important question is, does he possess skill he claims to possess? So he should have a uh, 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 requisite diploma or degree to prove his skill. And their ordinary skill is expected from the court. Was doctor qualified to operate or to give anesthesia? Has he acted in a way an ordinary skilled doctor would have acted in the same way in the same given situation? So it is proved that reasonable care is taken. So ordinary skill and reasonable care is sufficient if it is proved in court of law to get rid of any allegation. So, did he exercise his skill with reasonable competence? It is considered. And standard requirement is doctor needs to exercise ordinary skill in his profession, and he is not expected to have high skill in his branch. So negligence has to be gross and high degree of recklessness. And at that time of Jacob Matthews decision, Supreme Court came up with 3 guidelines that private complaint may not be entertained unless complaint has proved a prima facie evidence. So there should be prima facie evidence of negligence on part of treating doctor. And in guideline 2, their opinion should be independent and competent and non-biased. So it should be preferably from government hospital of respective department. And guideline 3 was doctor accused of rashness or negligence may not be arrested in a routine manner unless his arrest is necessary for furthering the investigation or collecting evidence, or officer feels that doctor may not make himself available to face prosecution. And the same type of one more case was decided by Justice Kaju, that is Martin D'Souza versus Muhammad Ishfaq. And Justice Kaju has stressed importance of expert opinion in medical negligence cases at stage of admission itself. And in this case, it was urinary tract infection, and patient was put on amikacin. In due course, patient was discharged, and he was advised to discontinue amikacin, but he continued to take amikacin, and ultimately he entered into hearing problem and case was filed. So in this case, Justice Kaju has also very good points as far as this decision of this case is concerned. Because patient took discharge from hospital on his own, and he continued amikacin in spite of verbal advice to stop that very treatment. And amikacin was life-saving, which was more important than hearing impairment. So this inference was taken by Justice Kaju in that very case, and case was decided in favor of doctor. And in that very case, observation on part of court was law is watchdog and not bloodhound. So if reasonable care is taken by doctor, then doctor will not be held negligent. So doctor need not to worry. And Bolam test should be used while fixing medical negligence. And doctor is expected to have ordinary skill, and he had taken reasonable care. All those guidelines which were given in Jacob Matthews was repeated in that very case. And one more guideline Justice Kaju had mentioned, if police has over-exercised power, then police is also liable for punishment. So as far as legal opinion is concerned, is there any apprehension of being prosecuted criminally? Call your colleague and family friends and manage for bail. If section 304A is applied, bail is granted at police station level only. But if you have suspicion that section 304 is applied, then you should approach to have anticipatory bail and handle the situation very effectively. One more act, that is MTP Act 1971, it is also triable criminally also. If center is not registered, if person is not qualified, if valid consent is not taken in Form C, all are this situation may invite litigation under MTP Act, and there is a provision of imprisonment 2 to 7 years. And as far as record part is concerned, a fine of rupees 1,000 is there. So it is very clear. But under this Indian Penal Code, even today, to terminate pregnancy is criminal offense. But if pregnancy is terminated as per provision of MTP Act 1971, then one out of this problem. Because in that MTP Act, it is very specifically mentioned that notwithstanding anything contained in Indian Penal Code, a registered medical practitioner shall not be guilty of any offense under that code or any law time being in force if pregnancy is terminated by him in accordance with provision of MTP Act. So, if pregnancy is terminated in provisions of MTP Act, then all these criminal sections will not be applied. So this is section 3012, 3013, 3014, and 16. They are section in Indian Penal Code related to abortion services. But if we have terminated pregnancy in accordance with MTP Act, then will not be applied. One more area, that is PCPNDT Act, it is also one criminal cases, and under this act it is cognizable, non-bailable and non-compoundable. Cognizable means investigating officer may have cognizance without permission of court and he may initiate investigation. Non-bailable, at police station level, bail cannot be granted and bail only be granted in court. And non-compoundable means case cannot be withdrawn in between and result has to come. It could be in favor or against. One more area, never detain patient for recovering the fees, because you may invite wrongful confinement under section 340 of Indian Penal Code. Patient cannot be detained for non-payment of fees. There are some other ways to recovering the fees, that is civil suit and so, but you cannot detain patient for recovering the fees because there is a provision of imprisonment of 1 year and or fine of rupees 1,000 or both. There are some other areas as far as criminal liability is concerned. Section 172 to 119, absconding to avoid service of summons or notice. If you are served with a notice by court or by government authority, and if you have absconded from service of notice, and if you have not replied or if you have ignored, then these are some clause in IPC which may be applied. And one more area, giving false evidence. When you know that whichever evidence you are going to give in a way of certificate or so, and it is wrong if you know, and if you submit, then it may invite fabrication of false evidences and giving false evidences, and you may be triable under section 191 to 220. One more area, using a true certificate known to be false. This is also one more area. And disappearance of evidence. So, say for example, if it is a case of minor and termination of pregnancy, you have to preserve product of conception and it is to be handed over to the police. But if you have not preserved or if you have destroyed it, then it becomes a disappearance of evidence and section 201 to 204 can be applied. One more area, section 268 to 278, likely to spread infection. Here comes Biomedical Waste Disposal Act also and Environmental Act also. But under Indian Penal Code also one is triable. If one is dispensing drugs, then and if at all adulteration of drug, then also one may invite sleep can make a big trouble. So an ounce of prevention is worth more than a ton of ore. This gentleman have so many staircases, but he doesn't know how to use them. So it doesn't matter how many resources you have. If you do not know how to use them, they will never be enough. There are so many provisions in law in our favor. There are so many cases decided in High Court, in Supreme Court, in our favor, our medical fraternity. But if we do not know, then they will not be useful. Have some basic legal knowledge and always obtain medical legal advice whenever you are in. And if you want to simply this, take tender care of your patient, comply with the provisions of law, take Almighty God before going to sleep, and keep my visiting card before your. situation. So again, seeking your blessings and support for post of President Proxy election year 2024. All the best. Bless you and have a litigation-free medical practice. With regard, salute to all, and again to Dr. Sneha and Dr. Jyoti for inviting me to share my views about the subject. Thank you very much. Please do not assume. Please ask if any query, any question, if time and chairpersons permit. Thank you very much.
Thank you very much, Dr. Patel. Who can speak better than this? And whatever you spoke, it's not like a medical legal expert, you are like a legal consultant, and you are actually. So I believe we have covered each and every aspect of whatever litigation cases, what are the possibilities, what are the domains of the medical legal aspects we should take care. You have explained everything so nicely, so nicely. Thank you, Dr. Patel. I believe whoever has listened to this lecture will be benefited from your deliberation. And I think Sneha, your endeavor is going to be very much successful, because this is a topic whichever we discuss to whichever extent, there is still something new to learn from each of the speaker. No doubt about that. And when it is Dr. MC Patel, yes, he is going to deliver something new. He is going to give something new input to all of us. Thank you so much. Thank you very much, Dr. Patel. Excellent talk. Excellent.
Thank you, Samal, for your
election.
Thank you, sir.
For your election.
Thank you.
One line I want to
Thank
say.
you, Shamalda, for joining.
Yes.
Thank you so much for excellent inputs as well. Thank you, sir. Thank you so much
Yeah,
for your excellent.
Ragini madam was telling something.
I
Yes,
just
yes,
want to
Dr.
say,
Ragini,
Ragini,
please.
sir, your talk is really every practicing doctor should know about it. It is not only for gynecologists. Every doctor should know this, all those sessions and all you. So this is my request. If possible, you make a flyer of this and send to all.
Oh yes. Yes, my pleasure.
Thank you, sir. Thank you so much.
Yes.
Thank
I'll be
you.
sharing the recording also, Dr. Ragini, to you, and of course to all the groups. I'll be sharing the recordings. Those who could not attend, we always share the recording. Thank you so much.
And Sneha, I would have to take your leave from this because I have to catch train.
Sir, I know that.
Thank
No problem, sir. Absolutely. Thank you so much, in fact, from joining with your busy schedule of traveling also. Thank you, sir.
Yes, I have joined from Virar. Yes, Dr.
Hello,
Deepak
Dr.
Desai's home.
Deepak.
Yes.
Good to see you.
So Deepak could manage for me to deliver this talk from his home only.
Good.
Thank
We
you,
all are
thank you.
benefited. Thank you, sir. Thank you
Thanks.
so much. Yes, any other comments? Otherwise, Suega, you can invite the second.
For the next talk, yes, I hand over to Monica to introduce our speaker and our
Thank you.
chairperson.
Thank you, MC Patel, sir, for delivering such an exhaustive talk. And thank you, chairpersons, Ragini madam and Shamal sir, for joining us today. We now move forward for the next academic talk. Our chairpersons, Dr. Rekha Rajendra Kumar madam. She has been a practicing gynecologist since the last 31 years, and she's the president currently of the Bangalore OBGYN Society. She has been invited as faculty in more than 700 state and national conferences. She's the South Zone coordinator for the Foxy Infertility Committee, the chairperson of Infertility and ART Committee, Kasoga. She's also the chairperson of the Ethics and Medical Legal Committee, Kasoga, from 23 to 25. We welcome you, ma'am.
Thank you.
As a chairperson.
Yeah, thank you.
Dr. Sudesh Doshi sir will be delivering the talk on amendments in the MTP Act, as Dr. Nikhil Datar sir will not be able to join in due to some emergency.
Yes.
Rekha ma'am, we request. Yes.
At around 7:15 p.m. he will join for some time up for the discussion. So Dr. Sudesh will start the talk. Yeah.
Yeah, observed. I have observed. I have.
Thank you, Sudesh sir, for accepting our invitation at the last moment. Rekha ma'am, can you please introduce her?
Yes, again, on behalf of Benchmark series, again, I am happy and can I have Sir's CV? Sir's CV has disappeared. Yeah, Dr. Sudesh Joshi, thank you so much for accepting our invitation in the last moment, and we are indeed obliged. Sir is the senior obstetrician and medico-legal consultant. We have shared the platform on medico-legal issues many times, and Dr. Sudesh Doshi every time has given very rich experience about whatever he has known about his medical legal work, what has been done over the past 25 years. He has been working in the rural setup at Pandrapur, experience of delivering 15,000 babies at his nursing home. He was the chairperson of Adolescent Health Committee in 2016 to 18, Medical Legal Committee of AMOGS, that is 20 to 22. He is a member of various important committees, especially the PCPNDT of FOXI. He is the present president of Pandarpur OB-Gynec Society. In nutshell, Sir has rich experience on the subject of medico-legal field. Thank you. We are eager to hear you from Dr. Sudesh Doshi, sir.
Thank you so much, Dr. Rekha, for those kind words. I'm a small person in small settings, doing whatever I can do. Thank you for those kind words. Can I share my screen?
Yes, sir.
Some technical glitch. Can someone help me?
So please open the PPT first and then start sharing, sir.
Okay.
Yes, so we can see the slides,
Yes,
sir.
sir. Yes.
Please make it in full screen, sir.
Okay.
We can see the slides.
Yeah.
Yes, sir. Thank you.
Yeah. Thank
Yes.
you so much, all the coordinators, for making me a part of this a big opportunity for me to share platform with great stalwarts like all past FOXI presidents and to be FOXI presidents. I'm a small person working in small setup, and I'll be talking about amendments in MTP Act in 2021. Actually, the first step towards change is awareness, and the second step is acceptance. Now, we all have been very much aware of the MTP Act amendments for last 2-3 years. Now we have to accept all of them. Though there are few glitches still, Dr. Datar was discussing last week, but still, what are the amendments which we should be able to cope up with? And they are all of very good acceptance from all of us. Actually, we were the people, FOXI people, who are fighting for all these amendments, and we have made a very good point. And the government of India has thought over it, and for last so many years, the amendments were due. And 2021, we got all the amendments. This is a slide about all the chronology of MTP Act, 64 Central Family Planning Board, illegal abortions, maternal deaths were seen. So Shantilal Shah committee was set up, and they reported the submitted the report. Bill was introduced in 69, passed in 1971, and enforced from 1972. After that, the amendment came rules in 2003 when they introduced the medical abortion. Now, after that, this gazette was published and by the authority. And what are the changes which they have made? Now, since we are short of time, I will be talking point to point, but very specific. Now, definition of termination of pregnancy, which was previously in the Act of 1971, since there was no medical or surgical method of termination at that time, and only surgical method was there. So the definition was changed, and now the termination of pregnancy means termination of pregnancy by medical or surgical methods. That was included. Next thing, which is section 3. Now, previously we knew that for termination of pregnancy, opinion of one registered practitioner as defined by the MTP Act was required for termination up to 12 weeks, and from to 12 to 20 weeks, opinion of 2 registered medical practitioners were required. But this amendment made it more easier. They have made MTP law more friendly for the doctors and more accessible to the patient. So opening of only one registered medical practitioner, as per defined by the Medical Termination of Pregnancy Act, is necessary for termination up to 20 weeks. Whereas opinion of two practitioners would be required from 20 to 24 weeks. So when it goes beyond 20 weeks and up to 24 weeks, opinion of two registered medical practitioners would be required. Whereas beyond 24 weeks, then there is no age limit or gestational period limit, but the opinion will be formed by the medical board, which will be formed in the medical college as per government rules and regulations. So it is clear. Now, one more thing which we were using previously in the previous act, it said that when the pregnancy occurs as a result of failure of any device or method used by woman and her husband was the word used. Now the word husband is replaced by her partner for the purpose of limiting the number of children or preventing pregnancy. So this word partner is important. Now we are more liberal society now. What Indian society was very conservative in 1970s, now it is 2020. So we are more liberal. And we do not make it a compulsion for on woman that she should get pregnant from her husband only, but she can have a partner to be and there will be no problem in intermittent pregnancy, even if pregnancy occurs out of a wedlock. So marriage has nothing to do with MTP. She may get pregnant from her husband, from her partner, whatever way she can undergo termination, provided all the requirements are fulfilled. Now, previously, the section 5 said that no registered medical practitioner shall reveal the name and other particulars of a woman whose pregnancy has been terminated under this act, except to a person authorized by any law for the time being in force. And the punishment for that was only 1,000 rupees. Now the punishment has been increased to it shall be punishable with imprisonment, which may extend to 1 year, or with fine, or with both. Now, this is very important for us, and this is not what we had demanded, but I don't know why the legislature included this act, because this has caused more number of problems. For many times, the patient they want the discharge card on their name because they
Hello. Sir, you are not audible.
Sir, your voice is not heard.
Hello.
Sir, तुमचा आवाज नाही येत.
Some problem in the connection maybe. Hello.
Now we can hear. Yes.
Hello.
Please proceed, sir.
Yes, we can hear you.
Dr. Suyoga, sir, please proceed. We can hear you now. Please keep talking. We can check. ऐकू येत नाही, sir. Dr. Suyoga, the problem is only for me or for all?
What happened?
Yeah,
I think there is network issue.
Hello.
Yeah. From Dr. Sudesh, I think you need to share once again.
Yeah, okay, I'll do it. Yeah, can you see my screen now?
Yes, and we can hear you also.
Thank you.
Yes.
Thank you so much. So this is about the main act which has been changed. Now the rules which have been changed. Now very important thing and which has been more doctor friendly is about who can conduct a MTP. We know that for MTP, 3 things are necessary. One is indication, second is the place, and third is the person who can form the opinion and who can conduct the MTP. Previous law, there was no clear-cut view about who will form the opinion, who will conduct. But now they have said that who will form the opinion, who will do the MTPs. A person who is eligible to form an opinion is eligible to do MTP up to that extent. For example, previously it was C1, 2, and 3, whereas now they are included one more clause, that is CA. For example, previously all the gynecologists who are experienced and all those could do MTP up to 12 weeks, up to 20 weeks. Whereas people who had undergone MTP training under government auspices and who were not gynecologists, they were allowed to do MTP, surgical MTP up to 12 weeks only. But now they have decreased the qualification criteria for a person who wants to do medical abortion, so that more number of people will be eligible to give abortion services to the people in rural parts of India where qualified gynecologists are not available. So they have introduced a concept of CA. This is the eligibility for person to form an opinion to for a patient to undergo medical abortion, that only with pills up till 9 weeks, and he also can give the pills. So this is a registered medical practitioner shall have the following experience and training for conducting termination pregnancy up to 9 weeks gestation period by medical methods, namely, first is experience at any hospital of period not less than 3 months in the practice of obstetrics and gynecology, and has independently performed cases of pregnancy termination medical methods of abortion under supervision of a registered medical practitioner or in a hospital maintained or training institute of government for the purpose of that help. So what has been happened that previously it was necessary for a person to undergo training at a government institute to become eligible even to prescribe pills. But now, if you have done MBBS and after that MBBS, if you have a experience of period of not less than 3 months in the practice of obstetrics and gynecology, then you are eligible to dispense MTP pills. For example, give an example, a person has passed MBBS, he has completed his internship, and now he comes to my hospital, he works as a registrar or a medical officer at my hospital where obstetric practice is done, where MTPs are done. He works for 3 months in my hospital, then he becomes eligible to prescribe MTP pills, even though he is not a gynecologist or he has not undergone government training for doing MTP. So this is a huge breakthrough. Now more number of people have become eligible to give MTP pills. So this is very important. Now who will conduct MTP Act? Now again, those people who are eligible to do MTP for that gestational age are eligible to conduct MTP for that gestational age. For example, a person with 3 months experience, he can form opinion for MTP medical abortion, he can give medical abortion. A person who has undergone training at government medical training for MTP, he can do MTP up to 12 weeks. And whereas all other has done. Now, who will form the opinion? Same thing, as I said, that the training which is required for opinion, forming opinion will be the same training required for conducting the MTP. Now, these are the forms which we fill up while doing MTPs. We all know, and we should be very meticulous about filling these forms. Very timely they should be filled, and the register should be kept, and the form should be folded in the envelope, kept in the envelope, and the envelope sealed. Now, this is form 1 or the RMP opinion. Now, there is no change in the form 1 except for the one form that previously it used to say signatures of registered medical practitioners, because beyond 12 weeks we used to require 2 persons. But now only 1 person is required up to 20 weeks. So it is signature of the registered medical practitioner, singular. And secondly, the reasons specified from items A to E, out of which E, as I told, that the word husband has been replaced by partner. So that is the only 2 changes in form 1 RMP opinion form for terminating pregnancies up to 20 weeks. Now this is form 2, where a monthly summary which we submit to our local authorities. Now it has got lot of changes where previously it used to go, and so form 2 it will have major changes. One change is that the duration of pregnancy previously it used to be only till 12 weeks, 12 to 20 weeks. Now they have split up into up to 9 weeks with medical methods only, up to 12 weeks with surgical methods only, between 12 to 20 weeks, from 20 to 24 weeks, and beyond 24 weeks. So this splitting has been done. Then religion of women we know. Then termination with acceptance of contraception, separate they have done. Because when you are offering MTP, it is your duty to make aware of the patient that MTP is to be done only as the last resort, and her first duty or the couple's first duty is to use contraception. And if you have undergone MTP now, it is doctor's duty. And if we fail to give them counseling about contraception and make them use contraception, then we have misused the law and we have misused the government by doing MTP who are not following any contraception. Then the reasons, as we know, up to 20 weeks are the same, except that this has been failure of contraceptive method or device by a partner. Now, important is between 20 to 24 weeks. Now, we'll come to that forward. This is a bit more very interesting. Now, Form 3, this is the register which is kept at our hospital. We keep admission register. And 2 new columns have been added to it. Previously, it was a 14-point register. Now it is a 16-point register. And what they have added is the post-abortion contraception method, which we have used for the patient. Like we have done tubal ligation or intrauterine contraceptive device or OC pills or injectable, whatever method we have advised them and the patient is using, that is more important. And method of MTP which we have used is also to be given in that admission register. This is for statistical purposes, because after 5 years, 10 years, we see the admission register, we can see the changes. For example, a few years ago, when medical termination of pregnancy was introduced with Mifepristone plus misoprostol from 2003 onwards, I went back and had a look of all my statistics with one of my friends, and we could collect data of around 1,000 abortions. And we compared it with pre-2005 era when the medical abortion was not available, and post-2005 era when the medical abortion become available. And we could see that previously of the MTPs, almost 90-95% were done with surgical methods, whereas post when Mefe plus Miso became available, now almost 85% plus MTPs are done with medical methods and very less amount of surgical methods are required to be done. Now we will go for indications from 20 to 24 weeks. As we all know that our government now has increased the gestational period for termination of pregnancy with indications up to 24 weeks. Now, Government of India has thought very thoughtfully, and even our Foxy stalwarts have given their inputs in this thing, that for indications beyond 20 to 24 weeks, it should not be done as it is because someone wants it. Because MTP law is very liberal in India, we know that MTP is literally available on demand. But for beyond 20 to 24 weeks, the law should not be misused. And beyond 20 weeks, MTP becomes a little more hazardous, more risky. So the indications have been very wisely drafted. For example, the following category of women shall be considered eligible for termination of pregnancy under Clause B of subsection 2, Section 3 of MTP Act for a period up to 24 weeks, namely survivors of sexual assault or rape or incest. We know when sexual assault occurs or rape occurs or incest occurs, it is very likely that that girl or that woman may not approach the family members or the law or the doctors because of the inhibition. So it is very likely that she comes to us very late. As Dr. Sneha must be remembering in our good old residency days in Sassoon, always the unmarried primees, they used always to come around 18, 20, 22 weeks, and we had no choice, very few choices left. Because we always know that unmarried primees are definitely going to come very late because there is a taboo. She doesn't want to disclose her pregnancy. She herself is not willing to admit that she's pregnant. Then now people have means to doing a pregnancy test, but in 90s, those were not available. So invariably, those patients who are sexual assault patients or those of rape or incest or minors, they are likely to present late. That's why the limit from 20 to 24 weeks has been taken. Secondly, change in marital status during ongoing pregnancy. For example, widowhood or divorce during ongoing pregnancy. Definitely, she will not like to continue the pregnancy. It takes time. So she will be eligible to undergo termination. Women with physical disabilities. Now, women with physical disabilities, they can undergo MTP till 20 weeks also. Then why till 24 weeks? Because this has been specifically defined that major disability, which is clearly defined as per the criteria laid down under Rights of Person with Disabilities Act 2016 of Government of India. Then these women with physical disabilities, because they may not have access, they may not have means to reach the MTP center, they will have to, they may come late. So 20 to 24 is done. Mentally ill women, including mental retardation. And obviously fetal malformation, because now with ultrasound, we know that a lot of anomalies can be detected within a window period of 20 to 24 weeks, especially cardiac anomalies and all. So these late detected anomalies will be eligible to undergo termination without going to the medical board.
Yes, Dr. Sudesh, we are very happy to welcome Dr. Nikhil Datar, and I think it will be good that both of you discuss about this aspect in details for what are the amendments and how you all can guide the obstetrician gynecologists about this. I think so. I welcome Dr. Nikhil Datar, who is a senior obstetrician, gynecologist, and laparoscopic surgeon, vaginal surgeon from Mumbai, and he is the senior consultant of Cloud9 Hospital and also various hospitals in Mumbai, and he is a medical legal consultant and lawyer as well. So we are very, I would say, fortunate to have Dr. Nikhil Datar to join this discussion and guide us on this aspect. So we're eager to listen to you, Dr. Nikhil Datar. Over to you. Welcome, sir.
I hope that I'm visible and audible both.
Yes, yes, yes.
Okay. So first of all, thank you, Dr. Buyar, for inviting me. I understand that you must be under a lot of pressure. That's why your team must have missed out on, giving me an invitation, etc. Never mind. I understand the pressure that anybody who is a contesting candidate goes through while fighting for the election. So probably that must have been the reason for this kind of a miscommunication or whatever it is. Never mind. I have tried to adjust. And I have got few about 10 minutes. I'm not going to share any presentation or anything like that. I will just take or give some key take home messages and stop probably. Most of you must be aware of the fact that it is me and my case, that is Nikhil Datar versus Union of India, and 324 cases that we fought collectively in various high courts and Supreme Court, which ultimately put so much of burden and pressure on the government that they had to amend the MTP Act. So that is how the MTP Act got amended. I am very happy to say that although the MTP Act got amended and now we are able to do the terminations up to 24 weeks, there are a lot of lacunae in the amended MTP Act and the rules under the MTP Act. And that is why I have challenged the amended MTP Act and the rules also in the Supreme Court, and that matter is waiting for it being heard. Now, in the meantime, there have been two developments. Now, first of all, I do not know who was the previous speaker or the person who was talking, but he said that termination of pregnancy is more risky after 20 weeks, and that is actually totally untrue. There is a lot of international data as well as Fox's statement whereby there is no such.
Hello. I think
Freeze ho gaya.
I think yeah, he's frozen, not able to hear it.
Particular fact that why have they linked the marital status of a woman, with the weeks of termination of pregnancy? I mean, what has got marital status got to do? I mean, how does a lady who becomes a widow becomes low risk for doing a termination between 20 and 24 weeks? But why would a lady who is an unmarried single lady become suddenly high risk for 20 and 24 weeks? God alone knows why such kinds of funny things have been drafted, and they all have been challenged. I also do not understand why a minor rape survivor who is a 12-year-old girl or a 13-year-old girl, why should she not be allowed to terminate the pregnancy beyond 24 weeks? As a matter of fact, out of over 324 cases, there have been good chunk of girls who were minor rape survivors, and courts have permitted termination of pregnancy much far beyond 24 weeks of pregnancy by taking opinion of respective state permanent medical boards. Now, if unanimous opinions of permanent medical boards have been that yes, she should be allowed to terminate the pregnancy, why should suddenly from nowhere this 24 weeks cutoff should come into picture? Again, there is no real answer to this particular thing, and that also has been challenged by me. So I completely disagree with that particular thing that beyond 24 weeks or beyond 20 weeks, it becomes risky. One more message I want to give to all gynecologists is that we as gynecologists try to link viability concept with termination of pregnancy. And that's a completely wrong thing to do, because right from 1971, there is nothing to do with viability when it comes to MTP. So because 24 weeks is a viability period, that's why we should limit it at 24 weeks is a completely wrong notion. Because then in that case, somebody is 20 weeks or 21 weeks, but you wait for 3 more weeks, no, then that baby will become viable. So viability is not the criteria to decide whether to terminate the pregnancy or no. Criteria to terminate the pregnancy has to be as given by the MTP Act, that either there has to be a substantial abnormality in the fetus, or there has to be a grave injury to the health, both physical/mental, and or there has to be a risk to her life. Now, there are only 3 such kind of criteria. There cannot be any other criteria. So I do not understand why should an unmarried lady's pregnancy between 20 and 24 weeks not be terminated. Is her injury less grave than a lady who has lost her husband? Or are you saying that a 25-weeker, 12 years old minor rape survivor, her mental injury is less grave, so that she should be now disallowed from terminating the pregnancy? There is absolutely illogical kind of this thing that is there with this MTP Act, and that's why these few things have to be changed. Of course, we definitely welcome the fact that now MTPs can be done up to 24 weeks and also beyond 24 weeks, particularly when there are substantial abnormalities with the fetuses. Now, of late, few of you might have read my name once again in most of the newspapers because of 2 new writ petitions that I have filed and successfully contested and won in last 1 month. And let me tell you a little bit about that, and after that probably I will stop. So one was a woman, a girl who was 17 years old. She was having a living in relationship with a boy who was 21 years old. They came to the doctor for MTP because she was some 8 weeks pregnant or something. She was below the age of 18 years. And the girl said that it is a consensual sexual intercourse. There is no question of rape, etc., etc. Even her mother also had come. Girl's mother had also come. And the doctor, typically, as we all know, we are expected to inform about this under POCSO Act to the police because the girl is below 18. And the fact that she is pregnant, that means she has had a sexual intercourse. And just because she's below 18, her sexual intercourse automatically becomes an intercourse without any consent, because she does not have the capacity to give consent. So the standard teaching will be that we have to inform the police because we are under the POCSO Act, and that's why this is what is the standard process. But as usual, and most oftenly, we all of you must have had this experience that girls do not want to inform about this to police because genuinely there is no rape. Actually, they are all consensual sexual intercourse. And then the doctor called me up and asked me, what can I do? And I asked the doctor that, do you want to shove it under the carpet or do you want to become an activist like me? Doctor said, I am interested in becoming an activist like you. So now finally we have filed a writ petition in the High Court asking for the permission from the court to not disclose the girl's name to the police. And the Bombay High Court has allowed us to not disclose the name of the girl to the police, and they also instructed the police not to harass the doctor for the name and identity of this particular girl. And after that, this girl's termination of pregnancy has been done by informing the police that we are doing a termination of a minor girl, but her name shall be kept as anonymous name. Okay, so this is a development as far as the law of the land is concerned, as far as the POCSO and the MTP Act goes. But mind you that this is an interim order. This is not an order which is a final order. So it doesn't mean that from tomorrow each one of you should be able to do that without taking any precautionary measures. So you can still do that because it's a High Court judgment, and High Court judgment will have a precedence value. This interim order will also have a precedence value, but you will still have to do a certain procedure if from tomorrow onwards you need to do this. Of course, the matter is now kept for hearing in June 2024, I think 30th June 2024. So we are hoping that there will be a kind of a policy change as far as the MTP Act and its pronouncements are concerned. So that's one big relief will be brought in for most of the gynecologists who do see these young girls who are 17 years and 16 years and who really have consensual sexual intercourse. And we'll end up, and we have to, I mean, not that we want to do it by choice. I mean, not that we want to do it because we want to do it, but we have no choice but to inform the police. And ultimately, what happens is that we create new culprits, we create new criminals because those boyfriends of these girls, usually they are their classmates or somebody like that. So we actually end up creating criminals out of nowhere. Okay, because police comes, arrest them, the girl's identity gets undisclosed. Everybody knows that this girl has had sexual intercourse below the age of 18 years, etc. So private things become totally public, and which is not a happy situation for anybody. Doctor also don't want that to happen. But we had no solution. So now we are finding a solution, and we are on the verge of getting a solution. Interim order has already been passed. The girl's MTP has been done. The police has not harassed the doctor and the girl both. They have, obviously, because they don't know the identity of the girl, there is no question of arresting the boyfriend and all that stuff. So altogether, this is what has been the story. So this is an upcoming kind of a new thing as far as MTP Act is concerned. And the second thing that has happened is that I had a lady coming to me who was 25 weeks pregnant with tetralogy of Fallot in the fetus and beyond 24 weeks. So we referred her to the Permanent Medical Board. Permanent Medical Board said, yes, you can go ahead with termination of pregnancy. Permanent Medical Board did not talk about feticide to be done, which they ought to have talked about according to the Ministry of Family Welfare's guidelines or GR that the ministry had to file in my case, that is Nikhil Datar versus Union of India in the Supreme Court. Then this girl said that she wants me to terminate the pregnancy. She was not keen to go to a government hospital. And then the question came up in front of me as to, A, in a private sector, can I terminate this pregnancy, which is beyond 24 weeks? And B, whether it is correct to do feticide or no. Now, again, in this matter, there has been an order which has been passed by the High Court, whereby the High Court has allowed me to terminate this pregnancy in the private sector. This is probably the first ever in the history first ever in the history and first ever beyond after 2021, where the High Court has permitted termination in a private sector. Now, you may be aware of the fact, or in fact, you may not be aware of the fact that you are not allowed to terminate beyond 24 weeks in a private sector. And the answer and the reason to that is very simple. We all have seen Section 4 of MTP Act. Section 4 of MTP Act says that termination of pregnancy has to be done at a place. Places can be of two types. One, governmental hospitals, where no permissions are required, no approvals are required. And if you're a non-governmental hospital, then you have to apply and you have to take an approval of the place. And that is what we all have, these approvals. Some of us might be having approval up to 12 weeks. Some of us might be having an approval up to 20 weeks. Now, in the amended law, 20 has to be read as 24. So we can say that some of us would have approval up to 24 weeks. But what about termination of pregnancy beyond 24 weeks? Do you have an approval beyond 24 weeks? And answer is no. Why? Because the Form A in which you are supposed to apply for the permission, the Form A itself does not have a column only whereby you can apply for beyond 24 weeks. So it means the best ever hospital, maybe in Mumbai, say your Jaslok or your Bridge Candy or Bombay Hospital or Lilavati or Hinduja, can also still not apply for termination of pregnancy beyond 24 weeks. If you cannot apply, that means you cannot be permitted. And if you have conducted MTP at a place where you do not have an approval to conduct, then it will still be considered as illegal. And these views were expressed by me, and these views were confirmed by the confirmed by the Solicitor General of Maharashtra State. So we challenged that particular provision, and the interim order was passed, and I was allowed to terminate the pregnancy at 25 weeks. Second issue that I was able to solve was I was able to give them the evidence to show that it is important and necessary to do and conduct ultrasound-guided feticide prior to terminating the pregnancy. And this was also officially allowed by the High Court. So again, I was the first to conduct an official feticide and then terminate this particular pregnancy. Again, same story. Interim order has been passed. MTIP has been conducted. Girl has been sent home. But the larger matter is still kept open for discussions and for arguments. So again, that matter is going to come in the month of June. So these are two updates as far as MTP Act is concerned in terms of the messages. Once again, I want to draw your attention that if you have a similar situation, you can do it, but don't think that the law has got changed automatically because of a judgment or an interim order. The law will get changed. Law has not yet got changed, but you can still use this particular judgment to showcase and then do the MTP. So tomorrow, if you have a girl who is below age of 18 years, you may contact me and I will give you an SOP to follow, and you may be able to do the replica of what I managed to do at your place also. But you will have to do all that. You cannot just simply go ahead and say that Datar told us that he did one, so I am also doing it. No, that won't be allowed, and that might be, so that won't be the correct thing to do. So I think with those few little things, probably I will have to stop over here. I wish once again all the best for the webinar, and I again wish Dr. Sneha Buyar for her elections. Thank you very much.
Thank you so much, Dr. Nikhil Datta. In fact, indeed, it is very, very helpful to all the practicing obstetrician, I would say, and the entire gynae community of the India. Thank you so much for your valuable guidance once again. Thank you. Over
Thank
to you,
you.
Dr. Monica. Yeah. Thank you.
I request Sudesh sir and Rekha madam to please sum up as the chairperson, ma'am, the points, and so that we can move ahead with the next talk by Dr. Neeraj Nagpal sir.
Yeah, Dr. Sudesh, you want to tell something, or
I think
because
Dr. Monica, we can continue with Dr. Sudesh talk,
Yes,
whatever
ma'am.
left, and
yeah,
then
that's
we
what
will
I
sum
felt.
up. So,
Anyway,
Dr.
I
Sudesh,
had
please.
almost finished
Yes,
the
please,
law,
Sudesh.
and yeah, I had almost finished with the things. Last few slides were remaining. Now, I beg to differ a little between what Dr. Datar said. He's a great activist, no problem. And he has contributed a lot to changing the law. But he said that what has it to do, why the indications beyond 20 to 24 weeks have been kept different. Because people have thought a lot over it. MTP is not only a medical indication, but it definitely affects the society and has social indications also. So as I told you that the indications which have been kept between 20 to 24 weeks have been because, as we were discussing, that we know that patients are likely to come late beyond 20 weeks. We want to complete all the 20 MTPs in less than 20 weeks only. But unmarried patients, patients with rape, patients with incest, they are very likely to come late. That's why it has been, the indications have been kept from 20 to 24. Maybe we have different views. And as we said, between 2024, anomalies which are likely to come late, those are also likely to come late because diagnosis of ultrasound, cardiac anomalies, they become evidence around 20, 24 weeks. So that's it. And humanitarian settings and disaster and emergency situations as declared by the government. For example, we know it was Corona. In Corona days, the people are not allowed to come outside the home, the hospitals were not running, non-emergency services were not available. So it is very likely that the patient who wanted to terminate pregnancy could not reach the hospital in less than 20 weeks. That's why she came late, or a disaster or some other situation. So these indications were very well thought, but we may have different opinions on. Anyway, Dr. Datar is a very great activist, and he's fighting for all those lacunae and which have not been there. And few precautions for all of us. One thing is, if you have your center recognized under MTP Act, please do follow all the rules and regulations. Please do take all the consents in Form 1 and Form C. And the envelope thing which is there, that you have to take the consent of the patient, you have to form the opinion, fold that paper and put it in an envelope and seal the envelope and write secret on that envelope. And it is to be covered with MTP number so and so 2024 and please do that in time, because such small lacunae can create problems. Many people do not do these things. And one more thing which I want to make it clear, that you need not put the case paper of the patient in that envelope, or ultrasound report of the patient into envelope. It is only necessary to put the consent form, that is Form C, and the opinion form, either Form 1 in case of less than 20 weeks and Form E in case of 20 to 24 weeks. Only that opinion form and consent form has to be kept in the envelope, and envelope is to be closed and kept in custody. All other things can be your case paper. Secondly, you are not supposed to put the name of the patient anywhere in your indoor papers. So what you do is, when you diagnose the patient, your OPD paper will have the name of the patient. And when it is decided that she is going to undergo MTP, then you have to re-christian the name, rename the patient as MTP number 24/2024, make a OPD paper on that name, and then admit the patient on that name as MTP number 24/2024. And the anesthesia notes and the surgical notes will be done in that name, keeping the name of the patient secret. So this is the middle way which we can find out. So we can do such things. And one thing which the law is always helping her, the original act says that protection of action taken in good faith. No suit for other legal proceedings shall lie against any registered medical practitioner for any damage caused, likely to be caused by anything which is in good faith done and intended to be done under this act. So if you are doing MTP, you are doing under good faith, then the law will not punish you. So this is, I sum up my findings, and thank you, Dr. Sneha, for giving me this opportunity to talk. Thank you, Dr. Monica. Thank you, Dr. Suyoga. And I wish Dr. Sneha all the very best. And I know this time she will be coming out with flying colors. And we will in future, we would like to see you as a President Foxy also in next few days. Thank you so much.
Thank you so much, Sudesh. Thank you for your best wishes indeed. Thank you so much.
Yeah, thank you, Dr. Sudesh, for making it a very crisp presentation. We totally agree with you, because that the identity of the patient has become a very, very crucial factor nowadays. From ₹1,000, the punishment has jumped to imprisonment. So one has to be extremely careful regarding the identification, be it a married or unmarried girl, be it a minor or a major, and especially record of maintenance, that whether you keep it in the hospital, the registers, what we maintain, what we send as a monthly report to the CMO, the Form C, whatever you have mentioned. Yes, perfectly right. The second thing is qualification and training of the doctor who does the procedure also is different according to the gestational age, like the 3 months training, the postgraduate, whatever we say depends upon the gestational age. That is another important factor what I would like to say. And third fact I want to bring in here to the benefit of all the audience is the abortion termination, like we do for incomplete abortion, missed abortion, or blighted ovum, is outside the purview of MTP Act. So one is safe, doctors are safe, so don't combine it with the MTP Act. Point number 3. And point number 4 is there is still some confusion in Karnataka regarding the registration of the center which permits for MTP. Like we are still, even the authorities, what we have inquired, they're not very clear regarding the fact that the gestational age, suppose it is 20, less than 20 weeks, they say it's a permanent registration. If you are eligible to do for MTP up to 20 weeks, it's a permanent registration. More than 20 weeks, if you are doing MTP every 3 years, you are supposed to renew. That is a bit of fact in under confusion. So that point, I just wanted clarification on that point, because none of them are very clear here.
Ma'am, there is no confusion at all. PCPA Act says that you need a renewal after 5 years.
Yes.
But nowhere in the MTP Act has been mentioned that this place, once it is registered, needs any renewal. There is no renewal for MTP, no renewal for the place for MTP, no renewal.
Sir, see, my center has been registered for MTP, but they have written the expiry date, and they said they have written. Okay. Yes, I had this doubt because I asked many people, but this was the answer I got.
Then what you should do is you should write under Right to Information Act, sir.
Okay.
That is there any expiry for MTP center, registered center, and you point to point, you do it under information, Right to Information Act. My center registered such and such, but as per my knowledge, there is no expiry for the medical termination pregnancy center to be done. and please explain. You get underwriting, Right to Information Act. It will go through the government proceedings and they will come back and they'll say there is no expiry for the termination
Once
of
given
central.
Yes,
permanent
absolutely. No, I
registration.
think it is a permanent
No,
registration.
Yeah,
It's
even I
permanent
was
registration.
told by many people, so I had to keep checking, but they have given a date and they said renew after that. It is mentioned in particular.
So
no,
then
So
you
Rekha.
I
have to
think
point
Jamuna
out
Madam
there.
wants to say something.
Yeah,
Madam, please.
Rekha, I think what you can do is we have Bare Act books. They are
Yes.
very simple books. Take the latest one and show them.
Yeah.
yeah,
It's simple.
Bare Act is only
You
8
don't.
pages, ma'am. Only 8 pages. Empty Act is only 8
Yes.
pages.
Yeah, so you don't have to go for any right to information or anything like that. You are not telling by yourself. The act is there, which is written. You are showing them that act. Yes, I agree with you. A lot of DMHOs or the district medical health
yes,
officers, they are not at all updated with this
exactly.
LTP amendments. That is
Yes,
the reason they don't want to take a risk and they just wanted to, tell. Even
pass it
missed
on.
abortions also, they say, no, you have to register. Many places in districts, this happens.
Yes. So thank you so much for all the discussion. I think we have Dr. Neeraj Nagpal, our very eminent speaker, to speak on his very much awaited topic. So I think I'm sure all of you are eager to listen to him. So Dr. Monica, over to you for sir's introduction.
Yes, thank you, Rekha ma'am. Thank you, Sudesh sir, and thank you, Dr. Nikhil Datar sir, for an excellent discussion. I would now welcome Dr. Monica Singh madam to welcome our chairpersons for the next session. And over to you, ma'am.
Thank you, Dr. Sneha Puar, madam. Thank you, Benchmark Series. And thank you, Monica Umbarden, for inviting me here. I'm sorry for the delay in joining. I was moderating a panel with BSc committee. So this is the last talk of the session by our esteemed speaker, Dr. Neeraj Nagpal sir, who is past president IMA Chandigarh State Branch. And we have the chairpersons for this session, Dr. Jamna Devi Gudi Devni. Madam is Senior Consultant OBGY at Yashoda Hospital, Sikandrabad, and a medical legal advisor. She has got many degrees
I
and
think
lot of
we can
accolades.
cut short.
And yes, ma'am. And most importantly, chairperson of the State Medical Legal Committee currently. Welcome, Jamna Devi ma'am, for chairing this session. I also would like to invite Dr. Gorak Mandrupsakar sir for chairing this session, who is Consultant Reproductive Medicine at MCHS Islampur and Director of Angel IVF Clinic, Pune. Next, I would like to invite our chairperson, Dr. Suman Sinha, madam. Can I have a CV? Yes. Dr. Suman Sinha, ma'am, is a very senior consultant and a chairperson of a general surgery committee of FOXY. And we invite her, president of Ranchi OBGY Society in 21 to 23. And we invite madam to chair this session. And I would also like to invite Dr. Meena Samant, madam, for chairing this session, who is a senior consultant in HOD at Kurji Holy Family Hospital, Patna, Bihar, and president of Patna OBGY Society. Welcome, chairpersons, and over to you for introducing our speaker, Dr. Neeraj Nagpal, sir.
Can I take the honor of introducing Dr. Neeraj Nagpal?
Yes, ma'am.
Because I always look upon him and we listen to his talks and learn a lot. And he's the chairman and managing trustee, MLAG, ex-president IMA Chandigarh State Branch, director Hope Gastrointestinal Diagnostic Clinic, Chandigarh, and member of ASG, ESG, ISG, INASL, SGEI. And not only that, he's a fellow of International Medical Science Academy, Indian Society of Gastroenterology. And sir has done a lot of work on these issues, and he has been member of editorial boards and edited books, and a lot of chapters he has written, which I think all of us do read. And there are research papers in international and national journals. And sir, I think without much ado, I think we would like to listen to you and learn a lot.
Well, thank you so very much for the kind introduction. Am I audible?
Yes, sir.
Yes, sir.
Okay. There is some problem with my laptop. I don't know whether my presentation will run. But let's start. The topic given to me initially was, I think, slightly different from what I see in the program today. And the program says that I have to speak on Consumer Protection Act. So this is now nearly off the cuff. Consumer Protection Act has been bugging me for last more than 30 years. And we have tried to do what we could about it, as I will explain in my talks. But the fact remains, the problem lies with us doctors because we do not seem to have still realized the magnitude of the problem. And it is only when we have a case filed against us that we feel temporarily upset. But time is coming when we all need to be together to take action in this matter, because this is going to change the face and the way we work in medicine. So there was a lot of confusion when CPA 1986 came in, and there were multiple judgments from various high courts where, like the National Consumer Dispute Redressal Commission in 92, in two separate cases where IMA also was party and Qualified Medical Practitioners Association was also party, they decided that medical services by hospitals and doctors were covered under CPA, and this was not a personal service. But then they had also decided that lawyers would be also consumers under the Act. Again, in 1992, in A.S. Chandra versus Union of India, Andhra Pradesh High Court said that the services which are provided by medical practitioners must be construed as service, and the persons who avail these services would automatically become consumers. A slightly different view was taken by Madras High Court in 94, where they said if a doctor or a hospital is doing diagnosis and treatment, that would not come within the definition of service, but paramedical services, if are being provided by an establishment, they would be covered under the definition of services within CPA 1986. So all these matters, they finally landed up with Supreme Court, and the Supreme Court bunched up in VP Shanta and others versus Indian Medical Association. And in 95, they gave a clear verdict that doctors and their services, hospital services, all were covered within the purview of Consumer Protection Act. But they had also said very clearly that only outright cases of negligence would be adjudicated in consumer courts. And where complicated medical issues were involved requiring evidence of experts, civil courts would be appropriate. So this escape mechanism, or this what should I call, escape, in fact, was given to the doctors so that this argument that judiciary had no knowledge of medicine and medicine is a complicated science and two doctors may not agree on one single path, and expecting a lay person to take a decision would be an injustice to doctors. So to cover themselves, they had put in this clause that it will be only outright cases of negligence which would be adjudicated in consumer courts. Then in 2002 came the judgment of J.J. Merchant versus Srinath Chaturvedi. And here now Supreme Court says, no. Even where complicated questions of facts are involved, requiring evidence of experts, consumer courts can still adjudicate in these matters. So the issue of only outright cases of negligence was removed, and where expert evidence was needed, even they were included. This was well seen in the Kunal Saha case, where on video conferencing, expert evidence was taken from US, from doctors. And that was the classical example, I think, of this. They also said very clearly that this thing, the judges have no medical knowledge, because repeatedly I hear people come up with this argument, a medical board should be there, a medical tribunal should be there. Mind you, this argument was already taken up in 95 by our advocates in Supreme Court, and they had said that consumer courts will be dealing with many areas of service. People will be who are providing electrical services will be covered, architects will be covered, everybody who is in any kind of service would be covered. And you cannot expect all services to start demanding that judges who have knowledge of their subject only should judge them. So effectively, this argument was overruled by IMA versus VP Shanta and others. Very good. Let's see this judgment of 2023. Aarti versus Dr. Gagandeep Goyal, National Consumer Dispute Redressal Commission, not a district forum, not a state commission. This is a National Consumer Dispute Redressal Commission judgment. What does it say? It says removal of gallbladder instead of conducting laparoscopic surgery to remove stones in the gallbladder without the consent of the complainant was incorrect and against medical ethics. And no case has been made out that the surgery was essential in life-threatening situation. Such exhaustive knowledge of the judiciary flabbergasts me, and this is the reason why we need medical tribunals. Problem is to convince the judiciary that sometimes or a substantial number of times they are talking through their hat is inviting contempt, and so everybody keeps quiet. Our main objection to Consumer Protection Act and medical services is that consumer courts are summary proceedings. You make a complaint, the person gives a reply, there are certain affidavits which are filed, no cross-examination, no investigation, no arguments. Based on the documents, the courts are expected to give decision in a summary fashion, in a fashion which prevents a very long dragging of cases. But yes, when we looked at Dr. Desai's case from Mumbai, Tata Memorial, it only took 26 years to get him a verdict that he was not guilty of negligence. So these kind of things, despite the language that this is a summary proceeding, and in summary proceedings, basically, the aim is to find an excuse how to compensate the consumer. The consumer has had a loss. How to compensate the consumer? Some excuse is to be found, whether you have not taken consent or your documentation is not correct or whatever the reason may be. It may not be relevant also to what has finally happened in the case. But some kind of excuse is found and some compensation is awarded because the sympathy of the courts is with the consumers. What is my problem with this? In 1995, I had published a compendium of CPA medical judgments. There were a total of 113 cases of medical negligence which had been adjudicated and decided by courts, including consumer courts, up till 1995. So there were some cases who were even before 1986 in civil courts. But out of these 113 cases, then we published the second volume in 2004, and there were a total of 270 odd cases between 1995 and 2004. This time, we took out the statistics from Confonet, and from 1st January 2023 till 31st December 2023, National Consumer Dispute Redressal Commission decided 261 cases of medical negligence. The 54 state commissions, including their circuit benches, decided 1,048 cases of medical negligence. There is no way to find out the exact number of cases decided by the district fora. So we had used a formula from one state. We took the example of Haryana. And in Haryana, in this period, the state commission had decided 10 cases. And all district commissions of Haryana had together decided 170 cases. So this was 17 times in the district compared to what was decided in the state. The same formula we used for the total number we had, and we got 17,816 cases decided by district commissions. Effectively, total number was 19,000 cases decided by consumer courts in 1 year. Now, we have to realize that for every judgment which is given, there are at least 2 cases which are pending in courts. And this is a very, very conservative estimate. That means 19,000 plus 38,000, which is around 57,000 cases, are decided or are pending at one point of time in consumer courts. Why this figure is important? Remember that majority of the cases are being filed against MBBS doctors. They are the number of cases against Ayush doctors is bare minimal. Against dentists is bare minimal. So effectively 95%, 99% cases are against MBBS doctors. And 80% of these are related to hospitals and inpatient care, not so much to individual clinics. Which means if we look at 80% of this figure, it is 45,000. And total number of hospitals in the country is 69,264 as of 31st December 2023. What does this mean? This means nearly 0.662 per hospital is a case which is either pending. So at any given time, or at least in 2 years, there is one case which is either pending or has been decided against or for the hospital in consumer courts for medical negligence. The difference in the number of cases being filed is exorbitantly large compared to the 113 cases we had for over 20 years. So effectively, this number is exponentially growing. This is my point. And we are not including in this the number of out-of-court settlements. So many doctors come to me, Dr. Sahab, wo problem hui thi, IV lagaya tha, the finger got amputated, the gangrene occurred and finger was amputated, and we gave them 1.5 lakh. Now they are asking for 20 lakhs and they have gone to consumer court. These kind of out-of-court settlements happen daily, and they happen across India, and the number of these is much more than the number of cases which have been decided in a year by courts. Again, conservatively, if we take the figure as 2 times, then the total number of consumer disputes, whether in court or decided by court or settled out of court, works out to be nearly 1 lakh. And if we again look at the number of hospitals in the country, it is 69,000 only. So more than one case, 1.5 case, where either out of court settlement has been done, or case is still pending in court, or a dispute has been decided for a hospital. So all hospitals effectively are facing litigation, are facing disputes, are facing allegations of negligence, and this number is exponentially increasing. This is my basic issue. And it is increasing at a very rapid pace. We do not have the data. This is what I have told you is some degree estimation, some degree fact. We have some facts from my previous work which I have done. But if you look at the graph, if somebody were to draw a graph, this is exponential growth. And part of this is because there is a new formula to calculate the compensation which was introduced in Kunal Saha judgment. Earlier, it used to be a multiplier method, which was straightforward for roadside accident, and the compensation amounts were curtailed. With this new formula, the compensations are going haywire. Even in a government hospital in 2015, a total of 2,28,87,921 was awarded in the case of V. Krishna Kumar versus State of Tamil Nadu for not picking up ROP. And the pediatricians were penalized for this. The pecuniary jurisdiction in 1986 and in 2019 is now very different. in CPA 1986, if a compensation was asked for up to 20 lakhs, then it would come in district fora. Between 20 lakhs to 1 CR, it would go to State Commission, and more than 1 CR, it would go to National Consumer Dispute Redressal Commission. In 2019, what has happened is the change of pecuniary jurisdiction the terminology has changed. It is no longer what is the compensation which is being asked. Now it is whether the patient has paid more than 50 lakhs for the services. Now, which gynecologist has charged 50 lakhs for infertility or for cesarean or for hysterectomy? None. Maybe a few cases of liver transplant would cost more than this. But otherwise, all cases of allegations of medical negligence by this pecuniary jurisdiction will now come to District Commission. My problem with District Commission is District Commissions are not manned by proper judicially educated officers. This is dispensation. This is political dispensation which decides who is to sit in District Commission, and the society at large does not expect justice from District Commission. It is expected that when the matter goes to State Commission and National Commission, the matter will be decided on judicial principles. So if the person has paid between 50 lakh and 2 crores, then under those circumstances only the matter will go to State Commission. And if and only if he has paid more than 2 crores, can the case go to National Commission. So effectively, henceforth, do not expect any case to be filed in National Commission. 99% of the cases will be in District Commissions, and few of very rare will go to State Commission. The problem is there is no upper limit on what compensation has been asked for. If a person has paid 500 rupees consultation and he wants 200 crores to be awarded to him, all he has to do is he does not even need to file a court fee. All he needs to do is sit in his bedroom, go on his laptop and file an e-complaint against me in the consumer court. And like pizza is delivered, similarly, probably in the next few years, we'll expect compensation to be delivered to him in the next 30 minutes. Look at the way quantum of compensation has been rising. I have already shown you the number of cases increasing, but look at the quantum of compensation also increasing. Very prominent case, 1993. This was V. Chandrasekhar. He was the table tennis champion of India. And he was operated in Apollo hospitals, and he was awarded 17,37,000 in 1993. And it was considered exorbitant. After that, we had Spring Meadows Hospital case in 97, again around 17-18 lakhs was awarded. Then came Prashant Dhanaka, this was in 2009, which breached the 1 CR barrier. Then Kunal Saha's judgment, of course, which came to 11.6 crores. And after that, 76 lakhs, 73 lakhs, 80 lakhs, 1 crore, 73 lakhs, 9 crore, 85 lakhs. This has been awarded in a charitable hospital case, which did some cataract surgeries in a charitable rate in Tamil Nadu. And the Sessions Court there awarded 9 crore, 85 lakhs in this case. What I mean to say is there is a trickle-down effect, and if the Supreme Court can award 11.6 crores, obviously we are no less, so we can also award compensations in crores. And there are multiple judgments of more than 1 crore, which have come in the recent years. In fact, as late as 2023, we have had this in National Consumer Dispute Redressal Commission, 1.62 crores, Parikshit Dalal versus Santosh Hospital. I will touch this case later also. Similarly, Priyanka Tandon versus Bhatia Global Hospital, 1.5 CR. What I mean to say is, crores is rolling off the tongues of our district, state, national consumer dispute redressal commissions as if it is simple saliva. It's so easy. I don't know. Maybe in Mumbai, Chandigarh, we will find it very, very difficult for anyone to pay a compensation of 1 CR or 1.5 CR the way they have been asking. Asking, the people have been asking for 200 crores also, but this is what is being awarded. And why every doctor needs to be careful? No one is immune. Doctors from government, ESI, charitable, ESH, army hospitals, and private sector. Everybody is covered. No limit on what compensation can be asked for. Interest on compensation may actually be more than the compensation, and award may be more than the compensation which has been demanded. Patient has asked for, I think, 3,200, and the court, NCDRC, has awarded 5 lakhs in that case. So there is no rationale in the way things are moving. And now in 2019 judgment, the CPA, they have also mentioned very clearly that you can go and appeal only and only if you deposit 50% of the compensation awarded. Very clearly meaning a patient can go and appeal if no compensation is awarded. But a doctor, if he has to go and appeal, he has to deposit 50% of the compensation first. This could easily have been extended to whatever amount the patient is asking, let him deposit 50% and then go and appeal. But no, after all, that would be against public good. Number 2, earlier in Supreme Court, when cases used to be taken from National Consumer Dispute Redressal Commission, Supreme Court would say, we will accept only cases on where substantial question of law is involved, not on facts. So here, now even NCDRC, you cannot make an appeal unless there is a substantial question of law involved, not simply that these are the facts. District Forum has given a judgment which is against common sense. The State Commission has not agreed with our arguments. So kindly hear our arguments. No, you can't go to NCDRC on these grounds. You have to demonstrate that there has been a question of law which has involved, and then they have to decide. Compassionate compensation in Consumer Dispute Redressal Commission is creating the most heartburn. No negligence. The court says no negligence, but the patient is poor and has suffered a loss, and the doctor is insured, so please give him some money. This is a dispensation which for the doctor is very horrendous, because they have argued and defended themselves in courts for 7, 10 years. And then they are told, okay, you are not negligent, but you have to pay a compensation. Similarly, treating VIPs is becoming very dangerous now. And I can give you examples and examples, but then the worst part is cases in Consumer Protection Act can be filed along with case or a complaint filed in other areas, which may be judicial or quasi-judicial. So what happens today? A patient first files a complaint against a doctor to the employer. That employer may be the government, that employer may be a private hospital. Then he also files to the State Medical Council. He also makes a police complaint. This is all alongside the consumer court case which he has filed. Then he files the complaint to the Chief Minister, to the Prime Minister. Complaint to NABH, JCI, the accrediting agencies, asking them why they have accredited this hospital which is so negligent. And you have to defend yourself under each authority simultaneously on same fact, same matter, same opponents. Complaint is filed to ECHS, CGHS, Ayushman Bharat. Again, simultaneously in the consumer court, simultaneously in the criminal thing, and also to these authorities. Similarly, complaint to NRI cell, Women's Cell, SC/ST Commission. Complaint recently was filed under Juvenile Justice Act. Under Juvenile Justice Act, if convicted, even for 304 is 2 years imprisonment. Juvenile justice, there is 7 years imprisonment. Complaint under POSCO Act. National and State Human Rights Commission, High Court and Supreme Court under Article 226 and 32. And all this is besides the Supreme Court of WhatsApp justice and the media trial, which also the doctors face. So my point is, If you have to hold us accountable, hold us accountable. Have one tribunal where I can defend myself, has one appellate body where I go in appeal in case I find I have not been given justice. But this thing that there are 14, 15 places where a complaint is filed and I have to defend myself there for whatever reason. If NABH takes back my accreditation or if JCI takes back my accreditation, it is going to affect my bottom line. I have to defend myself there. If a complaint is filed with the chief minister and he marks it to the DHS forms a board, I have to defend myself before the board. All this is simultaneously while I'm defending myself before the police, before the CPA, before the consumer courts. This is what I find is the worst part of Consumer Protection Act, and which is something because of which we should be removed from consumer protection. The only thing good is a patient cannot file a case in civil court for compensation as well as consumer court, and this also is a judicial decision from 1998. This has nothing to do with the law. All other citizens in the country have this legal principle which protects them, which says very clearly that if you are being tried in any court against any opponent on same facts, you cannot be tried in two courts on the same issue for the same facts. आपने आज मर्डर किया है, आपका कोई केस डिसाइड हुआ है, you have been exonerated. It is not something which you can take to the opposite party can take to another court and say no, fine, now you re-look at this matter in a parallel fashion. This is something which cannot be. This is called issue estoppel or res judicata. But then doctors in India, especially modern scientific medicine doctors in India, are probably not citizens. And that is the basic problem. Under CPA 2019, we now have e-filing. I already told you, like you're ordering a pizza, that way a complaint can be filed. Video conferencing, district commissions filing in 99.9% cases. Deemed admissibility of the complaint after 21 days of filing. Person has woken up, he has made a complaint online. If the court does not decide one way or the other, it is deemed admitted. And after that, you have to defend yourself. Then, earlier it used to be where you have operated, that used to be considered the place where the case would be filed. The cause of action has occurred in Mumbai. The case has to be filed in Mumbai. Today, if I go from Chandigarh to Mumbai and want to sue the doctor there, I will come back to Chandigarh or maybe even to a smaller district, let us say Fazilka, so that the doctor to defend himself has to travel all that area for every case. This is a problem which is going to find more and more doctors trapped within it. And no fee for services paid up to 5 lakhs. 5 lakhs, how many doctors charge 5 lakhs for their services? No penalty for frivolous complaint. Yes, 1986 had a penalty for frivolous complaint. It was an exorbitant amount of 10,000 rupees. Even that now has been done away with. And now exorbitant compensations, as I said, have been awarded. Remember, if you are fighting a case and you are harassed and you think the case is causing distress to my family, or your committing suicide will not end the case. The case will continue, and substitution of legal heir or representative as party to complaint in event of death of complainant or opposite party was there in 1986 CPA 2002 amendment, plus in CPA 2019. This is also mentioned very, very clearly. So death is not an escape. What was the reason on 14th of May that Supreme Court decided that advocates should not be covered within the purview of Consumer Protection Act was? They said advocates are providing contract of personal service. This contract of personal service and contract for personal services is what was decided by VP Shantan judgment, where they said the contract of personal service is a master-servant relationship. Master says you do this, so that is not, your service is not within the purview of CPA. Whereas doctors, they provide, they and their patients have a contract for services, which means patient comes to you with abdominal pain. You decide how you want to treat, what you wish to do. So this is not a contract of personal service. My problem is 2008 Samira Kohli versus Prabha Manchanda judgment. You have said very clearly that once the patient is under anesthesia, you have taken consent for one procedure, you want to do another procedure, which you think is in the interest of the patient. Now, this judgment tells me very clearly, I cannot proceed. I have to let the patient come out of anesthesia, give a consent separately for the second procedure, and then only go ahead with the second procedure. Is this not master-servant relationship? I can do only what my patient has asked me to do. I cannot do anything which I think is in the interest of the patient. So this is a master-servant relationship, which makes it a contract of personal service. And if it is a contract of personal service, like advocates, we should have been out of CPA. Mediation has been added in 2019. E-commerce will be included. So all these online consults and all will also come in. There is a concept of unfair contract which has been included, which I feel will create more and more problems later. But this is because consent per se is a contract. And we do not realize it that it is a contract, which is where tomorrow the patient will turn up and say that this is an unfair contract, and which is why the consent should not be considered valid. Many reasons why doctors should not be within the purview of Consumer Protection Act. We were hoping and praying that this judgment of the advocates being in within the purview of this CPA would give us some kind of advantage. But the only escape valve they have given is they have said that the Honorable Supreme Court should create a larger bench than the 3-judge bench, and that should hear the VP Shantan judgment again. We had gone to Bombay High Court first in 2021 against the inclusion of medical services within the purview of Consumer Protection Act 2019. This was the case of Medicolegal Action Group MLAG versus Union of India. We lost our case there, and we went in SLP to Supreme Court, and it did not admit our SLP under Article 136, which is the power given to the Supreme Court to hear such cases. So it was on a technical ground. They have not heard the arguments in Supreme Court. And we had anyway made only one single point argument that it was not the legislative intent to include doctors within the purview of Consumer Protection Act. Ramvilas Paswanji had mentioned very, very clearly when CPA 2019 was being formulated that doctors would be dropped. And all the proceedings of the Lok Sabha and Rajya Sabha was placed by us there. We did not include the other issues because we had that time considered, and the legal view was the other organizations will have a chance to put up their arguments, and in those arguments, the other points like the consent of personal service and the consent for personal service will be covered. But now, anyway, we have already made a representation to Chief Justice and to Ministry of Law and Justice to create this 5-judge bench, and Medicolegal Action Group has asked for an opportunity to present our arguments. We are preparing our case, and hopefully, as and when this happens, we will be in court again against Consumer Protection Act. Ideally, we have given government representation that there should be a medical injury compensation and liability bill, which should be passed. So we have given an alternative how this compensation and accountability can go hand in hand without creating a hurdle for the doctor-patient relationship. But then they have a lot of ivory tower experts whom we have not been able to convince, even though they are doctors, because everybody in their list of experts is only from major institutions, whereas on ground, 70% of the healthcare in India is provided by small and medium healthcare establishments, which has no representation either in National Medical Commission or in Niti Aayog or wherever. So effectively, unless and until something is done to change this representation, it is going to be difficult, but we are going to try. Thank you so very much. I hope I haven't overshot my time.
No, sir. I think you
No,
did
no.
it in 30 minutes, I think. Thank you so much for that elaborate, explanation and about the PPA from the beginning to till today. And I think whatever is being, taught for doctors in the coming years, let's hope that something will come more friendly towards the doctors, health professionals. And I think, would you like to say something?
Yes, madam.
Dr. Madhu?
Yeah, Dr. Gorak and Dr. Meena Samant. Yeah, please go ahead. Yes,
Suman
Gorak.
ma'am also.
Yeah. Hello, good
Yeah,
evening, ma'am.
Gorak,
Sir, it
please.
was very nice lecture, and Mane, it was actually thought-provoking and very great. And you have given a very two important, clear messages that what the organization should do in coming short period to work for against this Consumer Protection Act. And second, very important thing, you raised a very great point of representation of the small nursing homes. And I think the organizations like Foxy or even IMA, they again have to do something about it. And even the lecture or the points what you made, many of the points they really we all as a member are unaware of. And thank you very much, Dr. Sneha madam, Dr. Suyoga madam, and Dr. Monica madam for inviting sir, because this was really a thought-provoking talk. And many things they will be now taken to the organization. And I personally, as the chairman of PNDT Committee of Maharashtra State, I will try to do something to gather representation of the small nursing in this case, and we'll get back to you, sir. Thank you.
Suman ma'am.
Basically, a lot of small nursing homes are disappearing now because of this corporate culture. And just mediocre hospitals are surviving. At least I see in Telangana area.
Same.
But the problem is we do not have data. Let us look at the data. Where is the data? We are not collecting that data. And when we are talking of small to larger nursing home conversion, this is happening in tier 1 cities.
Yeah.
When we are looking at the tier 2, tier 3 cities, the situation is very different. And sometimes when I'm seeing even in places like Chandigarh, we used to have 28 nursing homes at one time. We have 10 nursing homes today.
Yeah.
So the problem is the small and medium healthcare establishments are disappearing.
Correct.
And we do not have any representation either in National Medical Commission or to the government. Even everywhere it is institutional.
Yeah.
Director JIPMER, Director All India Institute, Director PGI, they are in their ivory towers. They have no idea what is happening on the ground.
Absolutely, sir. Agree, sir. Absolutely agree, sir. And you have raised this very important point, and that's why I said here there are so many leaders of the organization of the Foxy and IMA. So it is urged to all that the sir has raised a very great point, and we all should work on this.
But we have private hospitals, organizations also there, but they also don't come forward with their.
They are dominated by the larger players.
Yes, that's
And
the reason, sir.
And madam, another problem is those small hospitals or medium hospitals are run by the doctors, whereas the corporate hospitals are run by non-doctors who absolutely don't suffer nor do have the ideas of what problems we are facing.
Absolutely. They have nothing to do with the patient.
Yes, Gorak.
They have nothing to do with the patient as such, because they are their clients and money giving machines are there. No? That's why that is a problem.
They are looking at the bottom line.
Absolutely.
Exactly
as
this point I wanted to say that, they, because of these corporate hospitals, even the humanity aspect of the doctors, people are losing that aspect of doctors. They are taking it as a business and not a profession. So I think we echo the
Suman
same.
ma'am?
Suman, yes.
Yes, ma'am.
Thank you.
Ma'am, you're not audible.
You're not audible. Look in front, I think some issue with the audio.
Not yet?
Not
No.
yet, ma'am.
Now you can hear. We can hear.
Yes, ma'am.
You can?
Yes.
Yes, ma'am. Now it
Let me
is
my
audible.
speaker. Let me see the speaker. Yeah,
No,
it's
you are
full.
correct. Correct hai.
So I really wanted to thank Sneha, madam, for giving me this opportunity, and I wish her good luck for the coming elections. And I'm really overwhelmed. Neeraj Nagpal, sir, really, I mean, you have walked your talk and made it so clear to understand this CPA, and this out of court settlement is very rapid these days, and that is of not much benefit. What they think that if I go out of court, I'll be more wiser. It is not that. They try to blackmail,
exploit you.
Yeah, exploit. And one of my friend is suffering this. Sorry, one of my friends, she had some problem, and her lawyer advised her to go out of. She went there. Earlier it was compensation of 2 lakhs, and now it is 3 lakhs. Now they have made it 1 crore. So every coming day,
I think, Suman, we are not getting your voice, Suman.
I think
We're
she's
not getting
talking
your
about
voice.
out of court
Yeah.
settlement, which is
Yeah, yeah.
Yes, yes.
that is leading to blackmailing.
Yeah.
Probably out of court settlement also you should do
This
legally.
is a real truth story I'm telling about my friend. I don't want to take her name,
No,
but
no.
she was in trouble. So she took help of her lawyer. And after listening to her story and everything, they said you go for out of court settlement. But out of court settlement, earlier it was 2 lakhs or 3 lakhs. And then they were again bargaining. Now it has come to 1 crore. And the case has moved from civil court to now Supreme Court or something like that. So they are in big mess now. So it should not be, it always go to the real, जो बोलते हैं ना सही line पे जाओ, instead of going here.
नहीं, out of court settlement करे तो भी you should do it legally.
Legally written, everything written.
The term we use is it should be settlement in court.
In court, yes, exactly.
Either you go to Lok Adalat or you in Consumer Protection Act 2019, now there is a provision for mediation.
Yes.
You go to court in CPA 2019 and tell the court that we are going for mediation. They will refer you to a mediation cell and you settle the amount there. Once it is decided by Lok Adalat or a mediation cell, after that there is no appeal.
Correct.
Then tomorrow the patient party cannot turn around and say, no, I need 200 crores now.
Yes, sir. Actually, sir, what you told now, that provision many of our
colleagues don't know.
And that's why they try for out of court settlement. That is a problem, sir.
But they never try to consult at least some, members, those who have some knowledge. At least
Yeah,
they can guide
really,
them.
Anna, they don't go to the correct medical legal expert. They go to somewhere and then they are trapped.
I know.
So do we have Meena ma'am, Saman madam here for her comments?
No. I think she messaged me that because of some network issues, she has to leave. So
yes,
I think it was a wonderful presentation, Neeraj sir, and really it was thought-provoking. I'm sure that if you continue this discussion, it will go on and on. Madam Jamna Devi will also agree to me. Maybe sometime later, maybe we can just have sir's talk as separate with the interactive session. So thank you so much, sir, for your precious presentation as well as your presence. I thank all the faculties, and Monica, over to you for your formal vote of thanks. Thank you so much, Chairperson, all the lovely people. also contributing so much to this discussion. Thank you so much.
And wish you good luck, Sneha.
Yes, best of luck, ma'am, for your election.
Thank you,
Dr.
sir. Thank you
Sneha,
so much.
all the very best in your next election and your future endeavors.
Thank you, dear. Thank you so much. Thank you, everyone.
Best wishes, Neha Madam, and thank you, Benchmark Series, Episode 7, for conducting this wonderful webinar on medico-legal aspects, which had stalwart speakers and great chairpersons. I thank all faculty for participating wholeheartedly. I also thank my co-coordinator, Dr. Monica Umbardant, and thank you again, Sneha ma'am, for the opportunity. And hope we keep connected through Benchmark and keep doing wonderful programs. Thank you so much. Have a good night. Thank you.
Thank you, sir.
Thank you, all the faculty members.
Thank you, everybody joining. In spite of your busy schedule, I have already welcomed all of you at the inauguration itself.